Greetings, everyone. We are discussing the ZEP Court Case. The Helen Suzman Foundation is going to the Constitutional Court. We are guided in this discussion by an article written ground up news. The journalist is Tania Brighton. So in the article here, they are saying the Helen Suzman Foundation is opposing a bid by Home Affairs Minister Dr. Aaron Motsoaledi to appeal against the High Court ruling on the Zimbabwe exemption permit ZEP. As we have been discussing in the previous videos, that the Minister of Home Affairs is going to the Constitutional Court. They proceed here saying the Pretoria High Court found that his decision to terminate the Zimbabwe exemption permit program was unlawful and unconstitutional. Dr. Motsoaledi took the ruling to the Supreme Court of Appeal and lost. He has now asked the Constitutional Court for leave to appeal against the High Court ruling. Alongside the foundation, the Consortium for Refugees and Migrants in South Africa is also opposing his bid. So the appeal by the minister directly to the Constitutional Court is being challenged by the Helen Suzman Foundation and the COMSA. The acting director of the Helen Suzman Foundation, Sima Fakir, is extensively quoted in this article. Just to give you what they deposited in as their affidavit, their courts here, it says the court made findings that are entirely disposable or second-ended of this application to leave to appeal. First, on the common cause facts, the minister decided to terminate the program without any prior consultation with the ZEP holders, civil society, or the wider public. Second, he inexplicably failed to dispose to any affidavit in the proceedings, meaning there was no admissible evidence before the court that the minister had applied his mind to the staggering impact that his decision would have on the rights of ZEP holders and the best interest of their children. Close quote. They continue quoting the acting director of Helen Suzman Foundation in this article. I quote, the consequences of these two facts is that the decision was patently unlawful. Unless this court finds these common cause factual findings are wrong, the unlawfulness of the minister's decision is undisputable. Close quote. And then again, they quote here extensively. Here it says, I quote, the minister's nitpicking at parts of the full court's judgment does not establish the real grounds of appeal or any reasonable prospects of success. The COMSA representative is also quoted here. So the court, the Comrade Tufulefi Situmule says in the court here, even if this is correct, which is denied, the minister has explicitly stated that he was not willing to change or modify his decision. The decision was hence either unfair under the Promotion of Administrative Justice Act departure or irrational under the Constitution. These are the conclusions reached by the High Court, and there is no reasonable prospect that any other court would come to a different conclusion, close quote. So the main issue here in this court case is whether the minister did consult the holders of ZEP. In the press conference that the minister was addressing the other day, he did say that after the decision was taken, he then consulted each of the 178 holders of Zimbabwe exemption permits by writing directly to them, either sending emails, some sending WhatsApp messages, or even sending letters to the addresses that they have in the system. So that's according to what the minister says, which is being disputed by the Helen Suzman Foundation, which says the consultation should have happened before the decision was taken in terms of the impact it was going to have. And the other thing which the minister was raising and I also seen a number of people raising it in public comments, is that who else was the minister supposed to consult? Was it civil society? If he has consulted holders of ZEP, was he supposed to consult civil society? Was he supposed to consult the general public, that is South Africans, on the ZEP? So that's what this case is all about. So we be following closely this court case at the Constitutional Court, but also with the point that the Helen Suzman Foundation is making is that their decision to go to court was not to challenge the minister not to make a decision to terminate ZEP. It says the decision to terminate the ZEP, it is the minister's decision. But in terminating the ZEP, the minister, according to Helen Suzman Foundation, should have consulted the holders of ZEP in civil society on the impact this was going to have to ZEP holders and their families, particularly children who are school going. So we await this court case to hear what the Constitutional Court is going to say, whether it is going to agree with the minister, or it is going it is not going to agree with the minister. So it's an interesting case, but as always we always call on people to continue to apply as per the directive of the Minister of Home Affairs, while the legal course is ongoing, but people should abide by what the minister has said, applying for waivers. We are also disturbed that waivers are taking long to come. The minister says he's signing thousands of waivers, but we have people that applied in 2022 who are still waiting for the waiver outcomes. We have written to them to say what is happening, and we hope that people will get their waivers so that they apply for other visas. Please write in the comment section, like this video, circulate, subscribe to this YouTube channel. If you're on TikTok, please do follow us. Otherwise, goodbye.